Barry.
Hello, everyone. Welcome to Money Matters with Shannon Jackson, a personal finance show focused on moving you forward financially. On today's show, we're focusing on estate and inheritance planning. Are your affairs in order? Is your will up to date? If these things have been on your mind, then we're going to have some helpful advice for you today. Over the next decade, the largest intergenerational wealth transfer in Canadian history is expected to take place. And the dollar estimate of what is expected to be transferred is a huge amount of money. It's expected to be $1 trillion. And for those who are in a position to pass on wealth to beneficiaries, and for those who may be expected to inherit, that means that there's a lot to think about. And so joining me now for advice for you is Dayna Devonish-Montique. Dayna, welcome to the show.
Thank you, Shannon. It's a pleasure to be here.
So Dayna, you are a member of the Prost Lediard Law, Devry Smith Frank law firm in Midland, and one of your areas of practice is wills and estates. Can you give us a little bit more about your background and maybe a little bit more about your areas of practice?
Sure, I will do that. Thank you again for having me as a guest on your show. I'm very happy to be here. I am an associate at Prost Lediard Law, Devry Smith Frank, working out of the Midland office. So Devry Smith Frank is new to Midland, but they've been around for a very long time. It's actually the largest firm outside of the GTA, with offices spanning from Toronto to Haliburton to Whitby to Barrie to Collingwood and, of course, Midland. Devry Smith Frank is a full-service law firm, and we assist clients in every area of law. If you retain, for example, if you retain me for your estate planning, but you're also selling a property, I can represent you in your real estate transaction. If you have a corporation or if you want to become incorporated, we can help with that as well. If you're separating and you need a separation agreement to be drafted, we have family lawyers on hand who will be able to assist you. So we're really the one-stop shop for all of your legal needs. And being in Midland, it just makes it more accessible to everyone in Simcoe County, et cetera.
Absolutely. And have you always wanted to be a lawyer? How did you get into the practice?
Yes, I've always wanted to be a lawyer. So when I was growing up, I was told I was a talker, and there are two options, a lawyer or a politician. And I'm like, I'm not going to be a politician. So the next best option was to be a lawyer, of course. My trajectory of getting to where I am right now is quite interesting. I will get into that today, but I'm just happy to be able to be practicing and to be walking in my dream, basically. And it's quite a privilege and a pleasure.
Absolutely. I can understand that. So to help us to get into our discussion today, there's something being talked about called the Great Wealth Transfer. And the reason it's so topical is because it's estimated that $1 trillion is going to be transferred to beneficiaries over the next 10 years or so. Now, we know that Canada's high net worth population is getting older. According to research, more than 40% of Canadian millionaires are over 65 years old, and they make up nearly 250,000 of households in the country. Now, this wealthy demographic is expected to nearly double in size over the coming decade as baby boomers, so those that were born between 1946 and 1965, continue to reach that retirement age. And so this is also when the transfer of personal wealth from one generation to the next is going to take place, with, again, approximately $1 trillion being transferred, which is roughly 70% of that amount is in the form of financial assets. And so with this amount of wealth that's expected to be transferred, there's understandably a lot of questions that are going to be coming up. And the main one, I think, is going to be, are these families going to be prepared to transfer this wealth to their beneficiaries? So Dayna, how important is it for these families to be legally prepared for this?
So the Great Wealth Transfer has been in discussion for some time now, and it's quite interesting because the last time it happened was several years ago. We're seeing where baby boomers are retiring and some of them are passing away. And so they're transferring this wealth to their family members, their beneficiaries, et cetera. It's very important for not just the ones who are going to be transferring to be prepared, but also the ones who are going to be receiving. In the transfer portion, the testator or the grantor or whomever it is that's going to be given, they want to make considerations for how to manage the transfer, how to manage the money that's going to be given, how to limit their taxes that they're going to be paying. They also want to make sure that the legal structure, depending on the complexity of their assets, that is properly done, is properly planned. And the ones who are going to be receiving, they want to make sure that they also have their estate plan in order in the event of their untimely death, or if they don't happen to put the money in, in the right infrastructure or the right asset. So it's very important for everyone to be prepared, even if you're not going to be involved in the wealth transfer, meaning you're not going to be getting an inheritance. Estate planning is something that's very critical, and it's something that everyone, once you're over the age of 18, should consider.
Absolutely. And even going so far as even just having that will in place is such a huge step, I think, that every person needs to make, even if there maybe isn't something to leave to somebody else. I think there still needs to be that will in place. And so when it comes to leaving an inheritance, polls show that parents feel the need to do so, but also their children also feel the same way. So nearly half, about 47% of those who are 55 and older say it's the right thing to do to leave an inheritance. And also the majority of millennials, about 55%, believe it's a parent's obligation to leave an inheritance to them. So while the older generation feels it's the right thing to do, and as they prepare to transfer their wealth to the beneficiaries, they do have concerns, of course. And so a third of those in that position of high net worth Canadians, they have fears that their heirs won't be able to handle the inheritance. And nearly a quarter, about 20%, fear that their children won't be able to pass anything down to their children. And as well, just over a third say that their children don't have the financial literacy to be able to manage a potential windfall that might be coming. Dayna, are you surprised by any of these statistics?
So these statistics are not surprising at all. In my planning meeting with clients, these concerns are highlighted ever so often, and they're valid, of course. Inflation is at an all-time high. Cost of living is also rising. The two are not quite keeping up with each other, and there's a decline in financial literacy. So these concerns are they're valid, and it makes sense. So when I'm meeting with clients and they're worried about how much they're going to pass on, or how their children are going to utilize the money or waste it or squander it, et cetera, I normally tell them, if you worked hard for this money, yes, you should be concerned on what you're going to give your children, but also you're still alive, so use it. Enjoy it, spend some of it on yourself, enjoy a nice vacation, go somewhere that you've always wanted to go, because you've worked for it. Now, the entitlement for the children, saying that they should get it, on the one part, not so much that I agree. However, I also ask my clients, you've worked very hard for 20, 30, 40, 50 years of your life, and you have a legacy that you're going to leave behind. If not your children, then who should inherit this, right? And that's when most of them will kind of, they'll pause and they'll think, well, I don't want it to go to a charity, which is not a bad thing, but I also want to make sure that they get something. So I said, well, they're your beneficiaries. At the end of the day, you're no longer here, and you want to make sure that what you've worked so hard for actually pass to the persons that you've chosen. Because if your estate should be administered according to the rules of intestacy, which are quite nuanced, they may not go to who you prefer, right? So it's very important to have your estate plan done, at the very minimum, having a will to actually outline how your assets are to be divided and who your beneficiaries are and who's your executor that gets to do the administration of your estate. Now, for more complicated and complex assets and families, you may want to consider doing a trust. So you could do a testamentary trust or an inter vivos trust, and you could pretty much set up how you want the inheritance or what you're giving to your children to be managed, how much they use, how much they get per year, if it's passed on to a next generation, so on and so forth. So that the research or the stats have shown that 70% of inheritance actually does not pass to the next generation, which is alarming when you think about it. But it also, it's not surprising because it seemed like lotto winners. I think that the stats are 90 to 95% of them go back to losing everything. So having proper financial management, and I'm no finance guru. My focus is really estate planning, but having a comprehensive meeting or a comprehensive plan where you're not just thinking about what happens when you're gone, but also what happens to your money and your investments and what you've worked hard for when you're still here. So there are quite a few estate planning tools that can be utilized. There's quite a few steps that can be taken to, one, limit or completely avoid paying taxes. Of course, there's probate in Ontario and for most places, which is estate administration tax. And right now it's 1.5% of the value of your estate, with the first 50,000 being exempt. So if you're thinking about an estate that is worth 11, 10, 15 million, you're paying quite a lot in taxes, right? And you could also be open to capital gains and other taxes based on your assets and based on how the transfer should happen if you should pass away.
It sounds like as part of the sort of planning stages of planning how you would want your estate to be distributed, managed, and things like that, there needs to be some important conversations being sort of happening with family members. Would you agree that there should be some communication between those who have an estate to give to someone and those who may be receiving it?
So I always tell my clients, if you're in a planning meeting, you're the boss. You decide what happens to your estate, you decide what happens to your assets, etc. However, considering your beneficiaries are going to be the ones to inherit, and your executor, depending on whether or not they are a beneficiary, is going to be managing this transfer, a conversation is important. When you read estate planning books, they'll talk about having the family conference. When I think about a family conference, it doesn't have to be a very formal or strict meeting where you bring everybody to a round table and you say, well, we're going to discuss our will and we're going to discuss our estate plan right now, and I want everyone's input and everyone's opinion, etc. It doesn't have to be that structured. However, at very minimum, have a conversation with your children, your loved ones, your beneficiaries on who you want to be the beneficiaries, of course, what gift will be transferred to whom, and how it's all to be managed. That way, when the time comes and you've passed away and your executor is administering your estate, there are no surprises. Of course, when there are surprises and one beneficiary may not be too pleased with the gift that they're getting, it opens your estate up for litigation. They may want to challenge the will, they may want to challenge the executor's appointment, and there could be so many issues. Whereas if you have a conversation up front, an open and honest conversation, and you basically get the input of your loved ones and your beneficiaries, it will kind of give you an idea of how to plan your estate. Not to say that you should be influenced by them, because that's also a critical point, to make sure that when you're including your beneficiaries in your conversations, that they're not influencing your decision to the point of, someone could say that your will could be challenged on the grounds of undue influence. So having a conversation is definitely beneficial. I always tell clients, you don't have to let them know exactly what's in your will word for word or show it to them, but at the very minimum, at least let them know who you plan to appoint as your executor, who your beneficiaries are, what your funeral wishes are, because sometimes your family may not know, and sometimes they may not get to the will in time for your testamentary decisions to be taken care of. So it's always good to have those conversations, to be open about them, and to have them ever so often. It's not just have the conversation today and then you forget about it and you don't talk anymore, because your children will get older, your grandchildren, and your life changes because nothing is static. So it's important to have the conversation and have them ever so often as your life changes.
Right. So I think when it comes to transferring our wealth, there's definitely a lot to think about. And you actually talked a little bit already about how we want to give this money to those that we love and also to avoid paying those unnecessary taxes. So we're also going to get into, after the break, talk about a living will and what this is and maybe what kind of benefits are there for everyone. So that's all going to be coming up when Money Matters returns.
This program is brought to you by Ignite TV. Now you're in command. Visit Rogers.com for more details.
We can be hurt. We can be bruised. We can be broken. Slowed down, confused, and even numbed. But we can't be defeated. We're built on a foundation that's strong, our mission unwavering, and together we'll beat as one.
Welcome back to Money Matters with Shannon Jackson. Today, we're talking about estate and inheritance planning. Joining me for the discussion today is Dayna Devonish-Montique, who is a part of the legal team at Prost Lediard Law, Devry Smith Frank law firm in Midland. And as we talked about in our first segment, the largest intergenerational wealth transfer in Canadian history is expected to take place over the next decade. And there's been a lot of articles written on the subject about how affluent Canadians need to prepare for this transfer of wealth because, as we've already pointed out, there's a lot to consider. And we discussed some of the concerns that the older generation has regarding this transfer of wealth. And we also talked about the importance of communication, especially when it comes to communicating your wishes to your loved ones and your beneficiaries. But while talking about all of this is important, the actual planning of the estate is really critical. So we're going to get into that now. So Dayna, when you are planning how your estate will be distributed, it's important to be aware that some assets can be taxed. Can you go into a little bit more detail about what those are and how that happens?
Certainly. So when you're thinking about your estate plan, the main tax, of course, is your estate administration tax, which is also called probate. As mentioned earlier, probate right now in Ontario, it's 1.5% of the value of your estate. Now, there are ways that you can either limit how much you pay for probate or completely avoid it. And it's based on your estate planning tools that are utilized based on how your assets are owned. So if they're owned jointly, or if you have registered accounts that you have beneficiaries on, et cetera, you may be able to completely avoid probate or limit how much you're paying in taxes. Now, the types of assets that can be taxed, or the list is distinct, but I'll just mention a few of them. So for an RSP or a RIF that you can't roll over, of course, there's going to be tax in your year of death. If you don't have a qualifying partner or a child that you can pass on the RSP or RIF to, then of course there will be tax implications. Also, for non-registered investment accounts that are in your name only, they will be taxed at fair market value just before your death. Real estate. Now, if you own several property or across Ontario or in other provinces, you may be open to capital gains tax, which of course we know is quite substantial. If you have corporate shares, there may also be capital gains on the taxes. So it's quite important to have the estate planning discussion with the legal professional, with a financial individual, just so you are, one, aware of the tax implications that could be in effect if you should pass away, and two, how to plan and prepare for that, so that one, you are giving more money to your beneficiaries and less in taxes, right? I always say you pay when you're alive and you pay when you're gone. So it's always best to have your estate set up so that you are not being exposed to too much taxes.
Well, I talked about earlier that about 32% of Canadians have fears that their heirs may not be able to handle the inheritance that's coming to them. And we sometimes hear about how a parent or a grandparent will create a trust for their loved one. Is this something that should be considered when you are planning our estates?
So creating a trust versus creating a will, I mean, the trust can be in the will, and that's where it will be a testamentary trust. Or, as I've mentioned, you can have a trust when you're alive, or an inter vivos trust that is not within your will. And both can be revocable or irrevocable, depending on the complexity and how you want the trust to be set up. Now, when we're doing estate planning, it's the simpler, the better. Right? If you're able to identify who your beneficiaries are, identify how you want them to receive their inheritance, the simpler you're able to lay out your estate plan, and the most effective way is always the best way. However, if your estate is a bit more complex and you will have beneficiaries who are quite young who will be inheriting, or even if they're not so young, they're in their 20s or 30s, but you still want to have some control over what they do with their inheritance, for certain, you may want to consider doing a trust. Again, you can do a testamentary trust or an inter vivos trust. Now, in the trust, you can basically stipulate how much is to be given, at what age, the discretion of the trustee, what the trust can be used for, whether it be for educational purposes, whether it be for buying a house, whether it be for buying a vehicle or a vacation. You can stipulate in the trust what you want your beneficiary or your trustee to be able to do and not do. And like I said, it can be included in a will. So it's not to say I'll do a living trust and not a will, because both are, if you need a trust, both are quite important. Your will has basic importance and necessities, because you don't want your estate to be administered according to the rules of intestacy, which, like I've said, they're not quite favorable. Under the rules of intestacy right now, a common law spouse has no automatic right to their spouse's property. So unless your property is owned jointly, or it's in a trust where they're the beneficiary, or it's a registered account where they're the beneficiary, your common law spouse actually has no right to your property. And so having a will, as basic as it may be, is very, very important, so that you are deciding from the outset who your beneficiaries are, who gets what, who gets to make the decisions, etc. If your estate is as complex where you need a living trust, then it's even more important to have the planning discussion with your lawyer, with your financial advisor, and how to set up that trust and outline the terms, the conditions, etc., that you want to be in the trust.
And now there's some perhaps families that want to see their family enjoy the inheritance that's coming to them while they're still alive. Can you talk a little bit about, you're talking about a living trust, and then there's this term of a living will. Can you maybe go through the differences between if there is a difference?
So yes, there is. A living trust, like I said, is an inter vivos trust. It's a trust where the grantor, meaning you as mom, you're giving something to your children, you're creating a trust, but you're still alive, and you can decide whether it's going to be revocable or irrevocable, et cetera. And you can decide the terms. You can also change the terms based on, life circumstances being different. A living will, on the other hand, and I'll try to get into that a bit later, is something that is instructive to your attorney, your power of attorney under personal care, on your end of life decisions. So if you're incapacitated and you're not able to make your own personal care decisions, you can include a living will in your power of attorney for personal care, instructing on your end of life decisions, whether you want them to pull the plug, whether you want, to be fed through a tube for a long time. And you can make those decisions ahead of time and put in a living will that can also be directly in your power of attorney for personal care document. retirement. So they're quite different. The living trust is of course, it's a trust that it's set up while you're still alive, whereas a living will, you're also still alive, but you're given instructions for your end of life.
Oh, I see. Okay. So it's possible then to stipulate to your beneficiaries while you're alive how you want the inheritance to, number one, to be distributed to them, and then perhaps as well how you want it to be used. Is that sound correct?
That is correct. So the living trust, you can have it set up with a deed of trust, or you can have a trust agreement, whichever ways fit when you speak to your lawyer and your financial advisor. And of course, the children or your beneficiaries, your grandchildren, et cetera, can be very well aware what's involved. I mean, they may not be too pleased if the conditions are quite limited, where they cannot use it to buy a new Lamborghini or take a vacation in Florida. However, you can have them become beneficiaries, or you can have a trustee and they're receiving from the trust while you're alive and while they're still alive. This way, you can also save on taxes and save on fees. You're essentially limiting the size or reducing the size of your future estate when you should pass away. You're also potentially avoiding estate administration taxes, because it's as if you're given while you're alive. Estate administration tax only come in effect after you've passed away. And of course, you're also reducing potential for family conflict, because everyone's still alive and they know what they're getting. And so no one can necessarily come and argue. And if they are going to argue, you're there to respond to it and say what the true intentions are. So when considering a living trust, you also want to consider your own financial health. If you are close to retirement, like we said, this great wealth transfer, everybody's turning 65, which is usually the retirement age, or if they choose to work for a bit longer, you want to make sure that when you're setting up this living trust, that you have sufficient funds for your own financial health. If you're going to be put in a home, or if you're going to stay in your home, but you need care in your home, you want to make sure that you have sufficient financial assets, etc., before putting it in a living trust. The other thing to consider when doing a living trust, you're giving it to someone else. You won't have much control over it. Depending on if it's revocable or irrevocable, you may not be able to get it back. So you must be prepared to accept that there is no option if the recipient chooses to use the proceeds in ways that you disapprove. So again, it's very important to have these discussions with a financial planner as well as your estate planning lawyer to make sure that the trust is set up in a way that is best for you as well as for your beneficiaries.
Well, I only have a couple minutes left, but before we go, can you talk about the importance of power of attorney or even an executor as part of this process?
Certainly. So executor and power of attorney, two completely different concepts. Your executor is someone that you appoint in your will. It's the person who is responsible for the administration of your estate after you've passed away. Your power of attorney, on the other hand, and sometimes I say it's even more critical, because while your executor is in charge when you're gone, your power of attorney does have impact over your life while you're still here. So your power of attorney, there's two types. There's one for property and there's one for personal care. And the one for property is actually a continuing power of attorney for the management of property, which means the person that you're appointing to be responsible for your property, they have the authority to do anything on your behalf except make a will, unless it's a limited power of attorney for property. And it also takes effect the minute you sign it, whereas your will comes into effect after you passed away. Your power of attorney for personal care is only in effect during your incapacity. Your power of attorney for property, the minute you sign it, it is an effective document that can be used by your attorney. So it's very important to consider who you're going to be appointing this authority to and giving all this responsibility, because like I said, they will and they can affect the quality of your life when you're still here. Your power of attorney for personal care is very critical. It's very critical because you cannot make a power of attorney or sign one if you're incapacitated. So you're deciding ahead of time, if you become incapacitated, who makes decisions for your care, etc.
Well, Dayna, thank you so much for being on the show today and sharing your expertise and advice. And I also want to thank our viewers for watching. Until next time, I'm Shannon Jackson.
call the Rogers TV viewer response line, email us, or connect with us on social media.
It isn't the heavy trays that make the job difficult, or the fast pace you need to keep up. It's not working another